Good afternoon, ladies and gentlemen. My name is Ioannis Lianos. I'm the president of the Hellenic Competition Commission. It's a great pleasure for me to welcome today our illustrious guests to discuss a very important issue that has occupied us national competition authorities and, of course, European Commission and others as well, which is Article 102 of the TFEU and its national equivalents. And the topic of our discussion is if there is a specific theory or we are still in search of a theory regarding Article 102 and the national equivalents. The purpose of this discussion will be to think creatively about the emerging landscape regarding the enforcement of Article 102 as well as national equivalent rules by the European Commission and national competition authorities. Not only the digital sector, which has occupied a lot our discussions the last year, in view also of the DMA, but also in more traditional economic sectors. In particular, we will focus on the different approaches followed by the recent case law of the EU courts regarding the interpretation of these provisions and the various theories of harm that have been put forward by the various litigants, in particular also the European Commission or national competition authorities, with the aim, of course, to understand the overall theoretical framework that is emerging. We have in this discussion an excellent panel. So in alphabetical order, we have Professor Pablo Ibanez Colomo from London School of Economics, Professor Eleanor Fox, who is a Walter Derenberg Professor of Trade Regulation at NYU Law School, Mr. Olivier Guersent, who is Director General of DG Competition, the European Commission, Mr. Giorgio Monti, who is Professor of Competition at Tilburg University, Mr. Martijn Snoep, who is the Chairman of the Netherlands Authority for Consumers and Markets, Professor Heike Schweitzer, who is Professor at the Law Faculty at Humboldt University, and Mrs. Marisa Tierno, who is Competition Director General at the Spanish Competition Authority. So we will structure our discussion in different parts. And I will say one of the issues that we will have to think about until 7 o'clock Greek time, 6 o'clock CET today, is the emerging case law of the court. I mean here the Court of Justice as well as the General Court. We had an intense activity from the courts at the end of 2021 and 2022 with significant judgments, and we're still expecting some other significant judgments shortly. And I think there are a number of issues that have been hotly debated the last few months. And some of them include the way the effects-based, more economic approach has been applied in the case law of the court, and what are its implications for competition law enforcement by the Commission the last 10, 15 years. We have actually a lot of time that has passed since the more economic approach. And of course, it's time to think about this approach, if there has been a specific success or there's more improvement to do there. Secondly, I mean, we have issues with regards to the distinction between price and non-price restrictions and the application of the as efficient competitor test. This has been an important issue in rebates cases, but the issue about the application of some form of efficiency test has come out also in other cases, broader exclusivity cases. We have actually issues concerning the application of the criteria of Oscar Bronner, and in particular the application of the indispensability criterion in other theories of harm and types of abuse. We have also a broader question about the way this recent case law of the Court of Justice and the General Court fares with a little bit older, but also some recent cases with regards to discrimination, leveraging, or naked restrictions, and how actually this case law might be affected or not by the broader, let's say, paradigm shift in Intel. We also actually have a debate about what is exactly the as efficient competitor principle as opposed to the test, and what is really meant by efficiency at the Court of Justice level. We have a number of advocate generals that equate efficiency with consumer betterment to the extent that they emphasize not only costs and prices as parameters of competition, but that are valuable for consumers, but also variety, quality, innovation. And of course, we have the recent draft guidance of the European Commission that also cites other parameters of competition, such as, for instance, sustainability that might, to a certain extent, be taken into account. Of course, there are issues with regards to the application of the broader framework we have for Article 101 in the context of Article 102. Do we have by-object restrictions in Article 102? Do we have some form of de minimis standards in Article 102? Can these de minimis standards, if they are, apply to even situations of naked restrictions or other more, let's say, form-based types of abuse that one could qualify as examples of impediment competition as opposed to performance competition? Are there any presumptions with regards to certain types of behavior in the context of Article 102? And how can we rebut these presumptions in the context of this specific article? Can we apply the same approach that we actually have, for instance, in the context of Article 101, as we have seen in the generics case law and other more recent cases? So that will be, let's say, the first part of our discussion. The second part of our discussion will focus on the national equivalence and the application of competition law by national competition authorities. We'll see the national competition authorities have made the choice of enforcing the effects-based type of approach and to focus on the more economic type of approach in their case selection, or have they somehow focused more on implementing some types of abuse for which we do not really have a more economic approach, or at least it's questionable if the more economic approach has affected this type of abuses. And it's an interesting question why, in case they have done so, why we've seen this specific type of development. And here, of course, we will also discuss the leeway that is offered to national competition authorities to enforce competition rules, in particular the national competition rules, in view also of Regulation 1/2003, and in particular Article 3, Paragraph 2, in case we have time. And of course, we will focus here on more generally the development of the application of the more economic approach. Has it been a success or a failure? How can we measure this in terms of cases won, lost, in terms of economic or consumer benefit overall? So these are interesting questions to reflect upon. And of course, we will have to open up our debate because, of course, the application of EU competition law is extremely important. It's part of our work here, national competition authorities and European Commission. But I think talking about more generally the global level, because many of these practices are imposed at the global scale. I mean, these are global markets. This raises the issue about the convergence of the EU competition law system with the US. Is the US competition law system, antitrust law, moving towards the same direction as the European framework does? Do we actually have any specific changes now with the recent changes in leadership of the Federal Trade Commission, the Department of Justice? Are we moving away from the Chicago and post-Chicago consensus in US law? How actually does the European framework fare with regards to the way actually the US antitrust law is moving? Is this really helping us, the more economic approach, towards more convergence or divergence in this context? So we unfortunately have only, let's say, 2.5 hours to discuss all these issues. So inevitably, we might not be able to address all the issues that I somehow sketched in this introduction. But of course, we have excellent speakers who have amazing experience and knowledge in competition law. And I will not waste more of your time, and I will move directly to the first issue, asking firstly Professor Pablo Colomo to maybe come first and discuss a little bit the first part of the debate with regards to the current issues of the day with regards to the interpretation of Article 102. Professor Colomo, the floor is yours.
Thank you very much. Thanks for the great invitation. And I would say congratulations on the timing. I think it's ideal to take stock on the developments we've seen over the past decade, and which I think have accelerated in the past couple of years. And to answer to your question more directly, how close are we to having a grand theory of Article 102? Are we going to get there, etc.? Well, I would say, as probably my fellow panelists will agree with me, that we're in some respects there, and in other respects, there's some clarification that we need. And this is what I plan to do in the coming not more than 8 minutes, where I pick a few issues where I think the court has been quite explicit in relation to some principles that I would say bring us closer to having this grand theory. But of course, there's also some uncertainties, there's some issues that haven't been clarified. And this is the structure that I will follow. So then I will start with the good news, I would say, or at least with the aspects that get us closer to this grand theory you were looking for at the beginning of this session. And in that regard, I will focus mostly on the issue of effects, if only because, as you were saying, the effects-based approach became a few years ago, as it became the symbol of the modernization of Article 102, as it was called back in the day. And when it comes to the issue of effects, I think the court has added a great deal of clarity, in particular in the past 2 to 5 years. And in that respect, I would say that, first of all, the first key clarification that came a couple of years ago in generics is that a practice, for it to fall within the scope of Article 102, it must be capable of having actual or potential effects. In other words, effects will be a precondition for the application of Article 102, which is not to say, and this is another important aspect to bear in mind, and I think the court has been explicit about it recently, that effects will have to be proved by an authority always and everywhere. So tackling one of the points you raised in your presentation, I would say that in some cases, effects are presumed, and that means that the category of abuses by object is very much a thing in the context of Article 102. So we have those practices where effects are presumed, and that means that these practices are prima facie abusive, irrespective of the effects that they have. And then we have another category of practices that will only be abusive where they are shown to have actual or potential effects. But from the perspective of an authority, it seems clear to me that at least in relation to some practices, effects need not be shown in every circumstance. Since we know since generics that a precondition for the application of Article 102 is the capability of anti-competitive effects, we also know, and Intel was central to this principle, that the presumption of anti-competitive effects that applies in relation to some practices can be rebutted. And I wouldn't say this is confined to certain practices. The case law that followed, cases like Servizio Elettrico Nazionale or Enel, as you prefer, are quite explicit in that front, and they're suggestive that this idea of rebutting the presumption of anti-competitive effects goes well beyond the narrow scope of rebate cases. Right? So that's the third principle. When it comes to what we mean by an effect, I think there we need more clarification. We may know that an effect is a precondition for the application of Article 102. We may know that the presumption of anti-competitive effects may be rebutted, but what is an anti-competitive effect is an issue where we need more clarification, which is not to say that the court has not provided valuable clarification in the past few years. Right? So then we know in particular that an effect is not equivalent or is not the same as harm to consumer welfare. I think the court has consistently held that what matters is the competitive process, which means that from the perspective of an authority, it would not be necessary to establish harm to consumer welfare. Right? So then harm to competitive process would be sufficient in and of itself. Right? So that's one side. Harm to consumer welfare is not necessary. Then the other extreme or the other end of the spectrum relates to harm to individual undertakings or individual companies. Again, from that side of the spectrum, I think we know from the case law that this would not be enough to establish anti-competitive effects. So then showing that an individual rival has been excluded from the market would not be enough. And this is something that we know, I think, from a combined reading of generics and Intel. I think generics was quite explicit in saying, in order to show anti-competitive effects in the context of Article 102, we need to show an effect that goes beyond harm to individual companies. The harm will need to be systemic in the sense that it will affect the competitive process as a whole. And that is, I believe, an important clarification that I think goes hand in hand with other aspects that have featured prominently in the case law in the past 5 years, I would say all the way back to post-Denmark II. One question that was being asked at the beginning of this session is that of de minimis. I think it is clear that the de minimis or the appreciability principle does not apply in the context of Article 102. But it does not follow from that idea that everything is an effect. So then we need to dissociate the two. We know that an anti-competitive effect needs to be systemic for Article 102 to come into play. And that means that not everything will be an effect. And from that perspective, I think a key manifestation of this idea is the relevance of coverage that I think has been very much present in post-Denmark 2, and I think features very prominently in the whole of the Intel saga, where the coverage of the practice will tell us something about whether the impact is systemic or at least sufficiently important for Article 102 to come into play. So then when it comes to effects, we know a great deal about what an effect is not. I think we need more clarification and more case law to get a sense of what an effect is. So those are four ideas. I think when it comes to anti-competitive effects, another issue that is clear on the principle, but I think not sufficiently clear when it comes to the implementation of the principle, has to do with causality. I think since Pons-Denmark 2 and in subsequent cases, the attributability of anti-competitive effects has been central. An effect has to be attributable to the behavior of the dominant undertaking for Article 102 to apply. I think this was present in Pons-Denmark 2, has been very much present in the Google saga. Then how much do we need to show in order to establish the causal link between the behavior and the anti-competitive effect is one area where perhaps more clarification will be needed. Then those are some of the ideas where I believe we have some certainty, or we're closer at least to getting the certainty that we need to come up with this grand theory, your ambition. There's one aspect that I would like to mention where I think we're still some way off having clarity from the courts. Right? So in the interest of time, I will focus just on this question, which is the threshold of anti-competitive effects that isn't required for Article 102 to come into play. And then whenever you have an academic on a panel, you may become suspicious that it may sound too theoretical or too abstract for it to have any relevance in concrete cases. But I would say this is one of the questions where I think clarity from the courts is absolutely central and will have concrete and actual consequences in practice. What do I mean by that? Well, when we talk about the threshold of effects, one needs to bear in mind how different it is to expect from an authority to show that the impact of a practice is plausible, or that the potential effects of a practice are plausible, or instead that they are likely. There's a very difference as a matter of substantive law to require plausibility when it comes to the evaluation of potential effects, or require more than plausibility. And if one thinks of Article 102 practices, this becomes particularly apparent. After all, we take action under Article 102 because most practices, such as time, such as exclusivity, etc., are at least a plausible source of anti-competitive effects in the vast majority of scenarios, right? And that means that if plausibility were enough for Article 102 to come into play, then the scope of Article 102 would be much broader. It would be, by the same token, much narrower if we require, instead of plausibility, we require likelihood. This is one area where we're far from getting any explicit manifestations from the court. If you ask me, some people might disagree. The sense I get, I think in line with Advocate General Cocotte back in Pons-Denmark 2, the impression I get is that the threshold is more than plausibility. We require, as a matter of substantive law, at least likelihood of anti-competitive effects, but this is again an area where some disagreement might remain and where clarity will be welcome. This is in relation to effects, to the effects-based approach, etc. I would like to close my brief remarks with just a final point, which has to do with a concept that was very much present in the early days, say late 70s, early 80s, which is that of competition on the merits. I would have thought, and perhaps I'm not alone when making this point, that the concept of competition on the merits was not as relevant under the effects-based approach. That the moment we accepted not everything is an anti-competitive effect, the moment we accepted that some practices are only abusive when if anti-competitive effects are shown, the whole idea of competition on the merits would not be particularly relevant or would collapse into the issue of anti-competitive effects. The notion of anti-competitive effects of competition on the merits would become one and the same thing. And this was my assumption until the recent judgment in Enel or Servizio Elettrico Nazionale, however you want to call it. And you will remember, all of you, that in that judgment, competition on the merit was front and center of the analysis of it. And I think this has resulted in the revival of this concept. Right? So then what does it mean for us? Well, the one question that might emerge is that of whether a competition authority would have to show in an individual case that a practice is not a manifestation of competition on the merits. And the impression I get from the remarks I've just shared with you and from my analysis of the case law is that an authority would not have to show, in addition to everything else, that the behavior is not a manifestation of competition on the merits, right? So then most practices will fall within the scope of Article 102 without it being necessary to show, in addition to all the rest that needs to be shown, that it's a manifestation of competition on the merits. But as I say, this is a concept that emerged in Enel, that has emerged in other recent cases, and which is likely to make a comeback. And I think this forum is ideal to share a few thoughts on that particular notion. I propose to finish my presentation here, and I very much look forward to other remarks. Thank you.
Thank you very much, Pablo. A very rich discussion, setting a little bit the stage for further thoughts. I will resist the temptation to comment, and I will pass the floor directly to Heike Schweitzer for his comments. Heike, the floor is yours.
Thank you, Ioannis. Thank you, Pablo, also for setting the scene. Like you, I would not follow those who currently claim that Article 102 is broken. We hear that once in a while these days. I don't think this is true, but what we see is that two sets of changes have occurred over the last 20 years or so, which intermingle in complex and difficult ways and rightly call our attention to Article 102 once again. So around 2000 or so, under the influence of the more economic approach, the idea has caught on that we should have more welfare effects analysis case by case in order to minimize error costs in individual Article 102 cases. And this has created a significant degree of uncertainty regarding the fate and the legal status of the old tests, of the former tests that we used to have before. And then from 2010 onwards, maybe, we have seen the wave of digital cases where we have learned that markets and business strategies have significantly changed and that at times the old tests do not fit very well anymore. And this is true both for the very old tests and for the effects-based tests. So the agencies and the courts are beginning to adopt the old tests and develop new ones. And in some settings, conduct that was formerly considered to be prima facie abusive is now analyzed based on an effects analysis. I would say this is true for the tying cases, Microsoft, Android. And in other cases, we see that conduct that might have been considered under, for example, the strict Bronner test, the former essential or the old essential facilities doctrine, is now considered under a different standard, for example, in Google Shopping, with some sort of discrimination analysis. I would say that this is not a problem of coherency of Article 102 doctrine. As Winston Churchill has once remarked, when the facts change, I change my mind. So this is what we should do. We should reconsider the doctrine. But in order to remain sufficiently predictable, we need to be particularly clear then on the fundamental baseline for assessing the lawfulness or the unlawfulness of conduct in order to modify the established tests. And here we do have, I think, some unresolved issues with regard to Article 102. And this is what I want to focus on. I want to look at whether we can, based on the court's case law, establish a clear baseline concept of an abuse that can also guide the adaptation of specific tests of abuse as applied to different categories of conduct. I will look at the effects analysis like you did, Pablo, with broad agreement and maybe some smaller points where I have a different tendency. If time remains, I will look at the Bronner doctrine in particular. So first of all, do we have a good baseline concept of Article 102? Do we have clarity and agreement regarding the goals of Article 102? Under the very old case law, the goals were relatively clear. So the abuse prohibition was to protect the internal market goal and competition as a process. And the goals and the concept of abuse were based on the specific capability of dominant firms to exclude rivals by way of conduct that did not primarily contribute to the efficiency of the dominant firm or the quality of its products, but primarily or disproportionately impaired a rival's ability to compete. So there was a focus on fighting artificially erected barriers to market entry. And the special responsibility doctrine recognized that the dominant firm was to obey a proportionality principle, in particular where the efficiencies could be realized by conduct that was less harmful to competition. Now, has this idea about the fundamental function of Article 102 changed in the court's recent jurisprudence? I would say no. We have the Enel judgment now, where the court recognizes that consumer welfare is the ultimate goal of Article 102, but the practical relevance of this finding is limited to rationalizing the efficiency defense. For finding a presumptive abuse, the Court of Justice remains guided by the idea that a dominant firm must not engage in conduct that impairs rivals' ability to compete, with a focus on the as efficient competitor principle. Of course, this Enel judgment raises many questions. What about the relevance of the internal market goal? This is a question I do have. What about the old case law on restrictions to parallel trade? Because the internal market is not mentioned anymore in this setting. What about the precise requirements regarding the effects analysis? This is something you have talked about, Pablo. What about the proportionality requirement? It is not mentioned in Enel, and I wonder why. And about the standard of proof regarding efficiency. So there are many questions that are raised by this judgment, but I don't think this is an issue with regard to the fundamental function of the abuse prohibition in our competition law. So I think in that regard, we are still on a safe floor. So then moving to the effects analysis. Pablo already has said a lot on that. We have seen a shift in the case law towards a requirement for more context-specific evaluation, more case-by-case effects analysis. Sometimes the case law requires an effects analysis for conduct that was formerly prima facie abusive, like in tying or loyalty rebates, and sometimes there is a need now for an effects analysis case-by-case required under the efficiency defense. But what kind of effects? And this is the same question I asked myself as you did, Pablo. Effects on consumers? No, this is not what needs to be shown by the competition authority. It may become an issue under the efficiency defense. This seems to be indeed about effects on consumers, but not for a presumptive finding of an abuse. So it is about effects on rivals. And the threshold that the court now seems to establish is the as efficient competitor principle. This is not new with regard to many price-based abuses. We have had it for some time in that area, and it makes a lot of sense in many of these settings. It is a practicable test in these settings, especially when the cost of the dominant firm can serve as a benchmark, which is not always the case, because sometimes in multi-product firms, we do not, is not a workable test in this regard. The test is not workable in non-price-based abuses, and it is not workable if we have in the presence of a company or dominant company whose dominance is based on huge economies of scale and scope. And in the old case law, these limitations were well recognized. Now in Enel, we don't see a sensitivity for these limits of the as efficient competitor principle. And I think that's a problem. I think we should not overstate the as efficient competitor principle as a relevant overarching test for all types of abuses. We should rather relate back to the fundamental function of the abuse prohibition on which we all agree. So what we have also seen following the debates on the more economic approach is, and following the debates on the digital markets, that we are starting to have a problem with the administrability of the system, of the enforcement of Article 102, with the length of proceedings, with the idea that law always must be an administrative system that needs to be applied by courts and by the norm addressees. And it seems that this is no longer the case. This is why we see this externalization of Article 102 now into the Digital Markets Act. And I think we have to, when we think about the future of Article 102, we have to think about this problem. Now, I think I've already overdone my time, and I will not comment on the Bronner case law, but rather pass on to you, Giorgio.
Thank you very much, Heike. Extremely rich discussion as well. And the Oscar Bronner, I keep it for the next round. So let's move now to Giorgio. Giorgio, the floor is yours.
Okay. Thank you very much, Ioannis, for inviting me. I've got 5 points I'd like to make. Some of these will respond to the points that Pablo and Heike have already made. So the first point, before we get to the court's case law, the court can only do and review that which the Commission or a National Competition Authority puts in front of the court. So we've got to ask ourselves the question, how can one design a legitimate and compelling Commission decision that proves the infringement to the standards that are increasingly highly set by the court? And one's got to wonder whether the recent decision-making practice of the Commission reaches the standard of excellence. We have very long decisions. We have decisions which are very sophisticated. In Android, we have the use of behavioral economics. So it's not as if there is no capacity. But one has to wonder whether the decisions always set out a clear theory of harm, whether it is always clear whether the evidence matches the particular elements of the theory of harm. Some decisions are very tidy. Some decisions look like they're written by a committee and different authors have written different bits. So I think it's important that, and similar comment can be made about references for preliminary rulings. NL has been discussed. What struck me about NL is the fact that a fairly experienced national court asks some very basic questions about EU competition law. Like, don't you know the answer to some of these questions already? So the General Court and the Court of Justice may sometimes be asked to be reviewing things that are not perhaps in their ideal state. And I think some thought needs to be given to how to better prepare Commission decisions. I'll get to this, or decisions by any competition authority. I'll get to this in a minute on how one might do that. My second point is that the court has escalated the standard of proof to a point where it becomes almost impossible to win. So in Android, you get these sentences where any doubt that a court might have can lead to the decision being quashed. That seems to me to be unsustainably high. There is a bit of a skepticism that agencies are there to get the weaker party. And so I think this, in a sense, causes, in my view, some of the concerns, because the only logical way to respond to this is to then have ever more detailed decisions where one loses the wood for the trees because you want to prevent that anything is doubtful. But if everything is fully discussed, then one loses the integrity of the decision. So what we actually need, this is my third point, is a more clearly spelled out economic conceptualization of the theories of harm, rather than saying this is tying, this is refusal to deal, to explain from an economic perspective why it is that this conduct leads to a type of anti-competitive effect that we have a problem with. And if you think about it from that perspective, a dominant firm's anti-competitive effects can only be of three types. Either the dominant firm protects its own dominant position, or it leverages its dominant position in order to become dominant in another market, or it leverages its dominant position to protect its original dominant position, defensive and offensive leveraging. So if a decision began by saying, I think this dominant company is trying to protect its dominance, or I think this dominant company is trying to extend its position from market A into market B, then already creates the space for explaining how the facts then can allow you to construct these theories of harm. So some discussion along those lines would allow us to abandon this categorization of abuses, its predation, its loyalty rebates, its refusal to deal, because all of these practices, in a sense, have the same objective. And the objective is very general. It's to either defend your dominant position or to conquer a market where you're not yet there. So perhaps abandoning the categories can help us think more freely about what it is that a dominant company is doing that we are so worried about. And I agree with Heike when she said what we're worried about is a dominant company erecting entry barriers, damaging the competitive process. But I think we can think about it in terms different from the categories. My third point is that if one looks at the case law in general, we see a trend away, and this has already been said by the other speakers a little bit, away from categories of conduct where the restriction of competition is identified by looking at the conduct and more towards an effects approach. We have some cases where there was a presumption, but with Intel now the presumption becomes rebuttable. It is not clear how much evidence the defendant needs to bring to successfully rebut that presumption, so we need a bit more clarity on that. But it seems to me that if you're an agency and you know that a presumption can be rebutted, you will anticipate it and build an effects case. So effectively, even though some conduct is presumptively anti-competitive, it may not be wise for a competition authority to rely on the presumption, knowing that the decision will be quashed as soon as the other party comes up with a plausible rebuttal. So in a sense, the procedural device in Intel has really substantively transformed the law on loyalty rebates. I think an agency would be mad to run a loyalty rebate without an effects analysis, relying only on the presumption. The court has also pushed back on structured conceptualizations of abuse. So if you think about tying used to have 4 criteria. Now tying has to be done with an effects analysis. So even a more abridged proxy whereby you can say an abuse of a dominant position is identified by identifying certain facts is removed, and we are moving to the third category. All cases have to have an effects approach where everything matters. And I think an approach where everything matters is not helpful, because if everything is relevant, nothing is irrelevant. And this is particularly clear in the Intel judgment of the General Court, where they say the Commission has to look at everything, including the intent to exclude. But intent may not be relevant. It's not as if you can compel an agency to always look for intent. There may be certain things that are more important than others. So just by saying we need effects, and I think Pablo's already said this, we need to think a little bit harder about effects, but it cannot be that everything is relevant. And I think Intel leads us a little bit into that trap about the type of analysis. But we are moving away from situations where we could condemn conduct just because it looks bad or just because it meets certain criteria that add up to a finding of abuse, to a situation where everything matters. And the final point I wanted to make is to speak a little bit about the AEC test. And I think here there's a misunderstanding on the part of the court in a number of cases about the as efficient competitor test. As Heike said already, this is not new. We've had it since AXO. In AXO, the court said, if the dominant company prices below average variable cost, an as efficient competitor cannot hope to compete. So what does that tell us? It tells us that the as efficient efficiency in the as efficient competitor test relates to productive efficiency, because it is saying if a competitor as efficient as AXO could sell at the price AXO is selling, it means that it is selling at marginal cost. So it is about the cost efficiencies. First point. Second point, the as efficient competitor is a hypothetical actor. It does not exist. What we're saying is, could a firm who is as efficient as the dominant firm, that is to say, with the dominant firm's cost structure, afford to price at the prices the dominant firm is setting? So what you're comparing is the cost structure of the dominant firm and the dominant firm's price. Is the price below the cost of the dominant firm, with an assumption that the dominant firm is productively efficient? That's all it is saying. So the General Court in Android is completely wrong when it says the purposes of competition law is to protect only as efficient competitors. That's not what the case law tells you at all, the ECJ's case law. It's not, the court never cares about who it is that it is protecting. It only uses the as efficient competitor test to create a benchmark, which is helpful because evidentially you only have the costs of the dominant company. It's not like when you're a competition authority and you're trying to penalize a dominant company, you ask the rivals, what are your costs of production? You ask yourself, is the dominant company pricing below the cost of production of the dominant company? Of course, by doing this, it will be not natural that some less efficient firms are removed from the market because the test is a fairly strict standard. But we're not comparing the dominant firm with the others. And indeed, I don't think there is any space for the notion of the as efficient competitor principle in EU competition law. It just doesn't fit within the analytical structure because we're never asking ourselves, do the other firms deserve to exist? What we're asking ourselves is the conduct of the dominant firm sufficiently damaging to the competitive process that it's reached a particular level that we want to penalize it? And that's got nothing to do with who it is that we're protecting. And just finally, as a general point, I'm a little bit more skeptical than my two previous panel members about the state of Article 102. I don't think we've seen a major paradigm shift ever. The case law has been relatively steady at a fairly high level of generality. However, one cannot escape the feeling that every case is almost decided on its own merits. So we seem to have some sort of casuistic approach. Google Shopping is the wonderful explanation. It is a problem because of all the very specific facts that occur. Android is a problem because of all the very specific facts in all the cases you can list. We do not have a general principle of why it is that all these cases are bad, except at a fairly high level of generality. And the suggestion I've made is that we can move to a much more cohesive general principle if we abandon the categories of abuse that we've been working with and think more generally about theories of harm from an economic perspective. And this leads me to the last point I want to make, which is the point that I think Pablo made about competition on the merits versus effects-based approach. And I think competition on the merits leads us to a casuistic approach. What is not competition on the merits? What we decide on the facts of each case. I think the merits of an effects-based approach, the advantage of that approach is that if we think harder about which effects matter, then we can create structured analyses that match the various types of effects that we have a problem with. And as I said, we just have two effects we're worried about: exclusion in the market and foreclosure and leveraging in another market. Thank you.
Thank you very much, Giorgio. Also very rich discussion. So we have, I think from an academic perspective, the presentation of various issues that have been raised by the case law. And let's turn now to the enforcers, and I would say the most important one in terms of size and relevance, the European Commission. So I would like to ask Olivier Guersent to share his views on what was mentioned before. Olivier, the floor is yours.
Thank you very much, Ioannis. I found the remarks of our three colleagues extremely interesting, and I liked in particular the remarks of Giorgio. I'll try to approach the same issues from a different angle because there are things that an enforcer cannot say, like the court is completely wrong and stuff like this. So I leave that to the academics. Let me take as a starting point, because I think it's a good starting point, the adoption of the guidance paper of the Commission on enforcement priorities for Article 102. So that's 2009. And since then, what have we seen? We've seen 26 court rulings on exclusionary abuses, both on appeals of decisions and preliminary rulings. And there's quite a bit of judgment that are still to come, and also additional general court judgments, Google AdSense, for example, or as the recent general court judgments move towards the Court of Justice in Intel, Google Shopping, Google Android. So all this is relevant in the discussion of the effect-based approach, like the one we have today. So now if I zoom out a bit and I look this bundle of evidence, what can we say? Well, the first thing I think we can say is that there was an endorsement of the effect-based approach by the core, and that is quite clear. The case law in the past decade has moved forward a full effect-based approach for Article 102. The guidance paper contributed to this as it aimed to address at least perceived formalistic approach to the enforcement of Article 102. I mean, I was one of the ones pushing to the 2009 guidance paper exactly to this, to move the ball forward. I may have succeeded a bit too much to my taste, but I'll come back to that. So the core of the debate today is, and that was a topic around which the three previous interventions revolved, how to run an effect analysis rather than is such assessment needed to be carried out. So it's a given, an effect analysis is needed. And this is quite an important development. It is in line with our enforcement practice, and I think it is to be welcomed. Presumptions may still play a role in certain areas, which is not really surprising, given that this is the case in pretty much any other area of law. But these presumptions, to the extent they exist, are always rebuttable. And for example, that's the case, it was mentioned, for exclusivity rebates. The courts have also confirmed, also in line with the guidance paper, that in order to establish a violation to Article 102, the specific circumstances and market conditions need to be taken into account. That's the point that was just approached by Giorgio. And key judgments on these points are, of course, the Intel Court of Justice judgments on Google Shopping, because they confirm that an analysis of all relevant circumstances is required for finding an infringement. So I don't know exactly whether Giorgio was regretting that there's too little principle and too much case by case. I think in general that each case needs to be judged on its merit is quite a good principle. In-depth scrutiny of Commission decisions has been carried out by the courts. Giorgio again mentioned that to the extent that it would become very, very difficult in some areas to reach the right standard of proof. I come to that in a moment. But anyway, what can be said is that both the General Court and the Court of Justice have engaged into a very detailed substantive review of the Commission's decision, which is in general healthy and positive for the credibility and legitimacy of the system. I wouldn't like to be subjected to a weak standard of review. I think that strengthens our system. But at the same time, of course, it raises maybe the more important questions in today's enforcement landscape. And it was asked by some of you, well, pretty much all of you in one way or the other. What is exactly the evidentiary threshold to prove in order to make a case for an abuse of dominance? And this is maybe an area in which it is not as clear as it could be after these 26 cases. So I think there is some added clarity that needs to be welcome on the standard of intervention. And there is no quite consistent string of judgments according to which, first, proving hypothetical effect is not sufficient to establish an abuse, and second, proving actual effect is generally not necessary. And the truth is somewhere in the middle. The standard of intervention are therefore crystallized in this in middle and is the one of proving potential anti-competitive effects. That's the case, for example, in the recent Google Shopping judgment, very prominently. And this standard applies pretty much to all different categories of abusive behavior, of course, with the necessary adaptations. For example, the initial and rebuttable presumptions of illegality for exclusivity rebates that I already referred to. So now, beyond this general consideration, the case law is still in flux, especially in terms of the evidentiary standards. So intervention standards, quite clear. Evidentiary standards to show a breach of 102. There, for example, the Google Shopping and Google Android judgments provide good example as to what is the type of evidence that the court considers necessary to run a solid abuse case. But on the other hand, in some recent instances, one can have the impression that the court have also taken the effect analysis very far, as was just alluded to. There is, of course, nothing wrong with assessing effects as such, but the standard should certainly not be set, and I think that was the point of Giorgio, at a level that risks making the enforcement of Article 102 in practice impossible, or very, very, very difficult. In other words, I think we have to make sure that the concept of effect-based enforcement does not end up meaning a lax enforcement of Article 102, because the standard of proof would be very difficult to reach. Let me take the example of the Intel Renf judgment, which, as you know, the Commission is appealing. And in that case, the General Court took issue with how the Commission calculated the contestable share of the market. The court considered that the document produced by Intel and referring to a only slightly different contestable share could, and I quote, cast a doubt as to the Commission analysis. And this was sufficient to annul the decision on this point. So we need to see whether this is an isolated instance or whether it is part of a more general trend. But if it is part of a more general trend, then that sets the bar for intervention very high, and I would submit probably too high. So that, I think, is the first lesson I would throw. Because crucially, the level of evidentiary standards that is required to prove an abuse has, of course, a direct bearing on the level of enforcement. It cannot be too low, but if it is too high, then you seriously prejudice enforcement in general. And in a world where we see increasing concentration levels, which in certain cases may well pose even societal rather than merely economic challenges, the enforcement of Article 102 plays quite a central role. And I wouldn't like to see a too high evidentiary standard result into under-enforcement of Article 102. I think this is an issue we ought to think about. We have also seen a number of other interesting developments in recent case law. Let me just mention two of them. First of all, it was widely debated, because it is, of course, to be widely debated, the as efficient competitor test. And there we now have much more guidance from the courts on how and when to use it. You may remember that the as efficient competitor test appeared prominently in our guidance paper. The stakeholders broadly understood the guidance paper as systematically requiring such a test in any price-based exclusionary conduct. Well, the guidance paper actually says we will normally carry out the test. The case law has confirmed that there is no general obligation for the Commission to do an as efficient competitor test for assessing price-based exclusionary conduct. The test may be warranted in predation and margin squeeze cases, and that you can find in judgments such as Post-Denmark, Intel, or Google Android. But they make clear at the same time that this is only one method of assessment. I think Google Android says it's a possible method of assessment. among others, in rebate cases. So in past years, we have learned that running the test is complex, that it implies very significant challenges. And the court confirmed that in Android, where it refers to the, and I quote, the difficulties inherent in drawing up an as efficient competitor test. So this raises the question of how and when we should practically use this instrument. And we are currently reflecting on this. I think it is good that in a way, the court has set the bar slightly less high than we had set it ourselves in our own guidance paper, because practice shows that you should not normally carry out an as efficient computer test. You should carry out in cases in which it is warranted. The second remark, but you said you wanted to keep it for later, so I'll be short, is on Bronner. And if you want, I can save it altogether. But I think that it's good that the EU courts have clarified now in several judgments that the Bronner criteria, and in particular the condition of indispensability, do not need to be shown in cases involving a constructive refusal to supply. For example, in Slovak Telecom or in Google Shopping. And I think this is a very welcome clarification, because that sets the standard of intervention to the right level. It's not unreasonably high, and it takes into account the fact that competitors who have already been granted access to an infrastructure determine their commercial strategies by relying on this access. So I'll say it's a mixed picture, which I tried to approach. I guess I've said the same thing that many of the things that my three predecessors have said, but taking it from a bottom-up approach from the case law of the courts rather than from a doctrinal approach, which kind of normal because I'm not an academic. Thanks.
Thank you very much, Olivier. This is excellent presentation. Let me intervene here. And of course, we all talk here in our personal capacity, let's put it that way. And I think everyone from my colleagues will agree on that. We don't represent our institutions discussing. I think there has been an interesting first element, this distinction between, let's say, the form-based approach will be one pole, and the other one will be, and I use here terminology by Justin Lindebaum, all things considered decision-making. I mean, in a sense, we are in the middle between either, moving to a more form-based approach with regards to the category of a specific conduct, which has a specific test, and the other side, or the other pole, will be the all things considered decision-making, where we will basically look to any possible related effect. So we try somehow to navigate between these two poles, and we try to see where the court moves. And of course, the court's case law, which intervenes in different periods of time, and the precedents, which apply sometimes from the 70s, sometimes from the 80s, 2000s, and more recent ones, they may have a different point of departure. We try to navigate in this difficult type of setting. So that would be the first issue to raise. The second one, which also, somehow relates to the discussion we had about the minimis and potential effects. I mean, my question is, is it the minimis here? Because I think Pablo referred to the coverage element, which I think is a different issue than the de minimis. Could we say that the minimis is also not just a quantitative concept, but also a qualitative one? And how can it be only a quantitative one if we are it's also possible to rely on potential effects? Okay, so in a way, I think that could be an issue to have in mind. I mean, this idea of a potential effect, which could be a more qualitative aspect of the de minimis here. And I would say, the third issue concerns the standards of evidence, the evidential standards. So Pablo made a distinction between plausible and likely standard, and to a certain extent, the question is, how these two could work in the context of a potential effect. I mean, usually we distinguish between the standard of proof and the cogency of evidence, and I'll refer here to the usual type of paradigm of the Alsatian or a lion in Regent's Park or Central Park, because Eleanor is here. I mean, I might probably use terminology of the Central Park. So it might make more sense to see an Alsatian in Central Park than a lion. So that's a congregation of evidence issue. But then there's a standard of proof, which is how this type of evidence is regulated. And there, I would say we might have a probabilistic approach, which is like it's more probable than not, or a relative plausibility approach. Now, probabilistic approach, if we take that approach, even like a 5 or 10 or 20% doubt, if it could create a problem if I follow Olivier's interpretation, or at least what he's saying that, well, we might have to see what the quote somehow meant in Google. But if you take a relative plausibility approach, basically it's a comparison between two different theses. Okay, so one is that there is a compelling story of infringement. The other one is there's no infringement, and then you have to somehow compare these two stories and find which is the most plausible one. And I would say there the issue is somehow different. So that could be the second element I wanted to discuss. The third one is about competition on the merits, and what Pablo said before about the idea that we need to always look to effects. And I was wondering how we can deal with issues like the ones we have in the case concerning Intel, the naked restriction part, which still stands. I mean, as we know from the most recent General Court decision in Intel, or the AstraZeneca type of cases, or the Irish Sugar type of cases, where or I mean, in the U.S. it could be the Conwood type of cases, where, for instance, there's a destruction of the product of a competitor. I mean, is this the type of approach that will consider that, well, it's not systematic enough, or it's not, or we consider that this is really problematic because that's not competition on the merits. So in a way, what I somehow indicate here, there might be another category of another reason for looking to the existence of the concept of competition on the merits, which is basically not just an economic assessment, but actually a normative assessment about certain types of behavior that don't make any specific, cannot be justified by the persons of efficiency or for the firm, but only can be justified by the fact that the firm was trying to create impediments to a competitor. And to a certain extent, why should we require in this context an effects analysis? I mean, the potential and effects in the sense of actual effects, the potential effect of such practice is basically to create impediments for a competitor. And in a way, we in this type of context, I mean, the argument of that artificial competitor will not fare well, and we know that because it has been tried in the Intel case of the General Court, which still stands, and the court basically said, well, I don't really have to apply the artificial competitor test here because, this is not an economic kind of assessment. I mean, it's the fact that this type of practice, and I quote, is depriving, sorry, let me just found it, is basically has a capability of making the market access more difficult, and to a certain extent, it's problem. It makes the market more difficult for the competitor. Market access more difficult for the competitor. So in a way, the court actually refused to consider the sufficient competitor test in this context. So fourth remark is: are we actually moving to the different concept of presumption? I mean, the presumption, and I think Gianni Calindiri has an amazing work on the concept of presumption. She says, if you have a presumption, they require, rather simply entitle decision makers to draw the entailed inference and to accept the presumed issue as true. And basically, one might somehow link one fact A, which in case it is established and there's a presumption, you are somehow called as a decision maker to conclude that fact B is true. So it could be a presumption between different facts. But does the case law on naked restrictions or regulatory abuses also refer to a different type of presumption where it's more normative rather than factual inference that we're discussing? So if there is fact A, you conclude to a normative inference B rather than a fact B. But then how can you disprove, how can you rebut this presumption? Probably you can do that by basically saying that fact A doesn't exist. But there's no possibility to say that, well, fact B basically did not occur, as you can say, for instance, in factual inferences, okay? So, and I would say that this is probably why maybe, you know, the court's insistence on competition on the merits and the reference in cases of the court that still exist and still good law with regards to the normative assessment that one might make in the context of an abuse could possibly, you know, tell a slightly different story than the one we have been discussing so far with regards to the effects analysis. And of course, you know, if you take a potential effects approach, this type of this could still be part of the paradigm. I mean, of course, you know, we have distinguish here between potential effects and hypothetical effects. I mean, we're not talking about hypothetical effects. We're talking about potential effects. So, so these are some of the remarks before going back to you for another round. I mean, in terms of the discussion, I mean, I'll probably call the people that haven't intervened so far with regards to our discussion on Article 102. And also, I would like to ask, I mean, are we really this idea, this uncertainty that there is with regards to the evidential standard and the fact that maybe we're afraid that this evidential standard set by the recent case law is pretty high, maybe too high if I use Olivier's reference. Is this something that might explain also the fact that, well, you know, we don't really have many Article 102 cases brought by the Commission? I mean, I was reading most recently a paper by Walter Wiltz on Regulation 1/2003, comparing the situation the last 20 years with the situation 20 years after Regulation 1762. And basically, you know, he concluded by saying, well, you know, we had fewer cases. So it says, well, we were supposed that this more effects approach to and the abolition of the notification system was meant to free up resources and allow the European Commission to adopt a significantly higher number of prohibition decisions. But what actually he concludes by doing this empirical analysis, he concludes that, well, in fact, we have slightly lower number of prohibition decisions in the last 20 years compared to the ones in Regulation 1762. Of course, he refers to the important role of national competition authorities, which have adopted, as he mentions, 90% of all the decisions in this period, so prohibition decisions. So saying, I mean, look, you know, somehow showing that the effect of national competition authorities is very important. But you know, it raises some issues with regards to the difficulty of the standard of proof concerning Article 102 cases and the more economic approach. And this has affected the number of cases brought. So these are various questions. So I will ask maybe starting with Martijn to intervene in case he wants, and then we'll move to the next speakers and we'll come back to the ones that spoke already. Martijn.
Thank you, Ioannis. Yeah, I must say that I share the concern that's also being expressed by the previous speakers, that the administrability of 102 cases, of exclusionary conduct cases, has not become, well, at least easier, and I think is quite difficult, and particularly for an NCA, and even an NCA that is relatively well resourced. If I look at our own agency, these cases are extremely resource intensive, not only in the investigation phase, but also before the courts. I mean, all these cases end up ultimately before the courts, and national courts tend to get inspired by the Luxembourg courts and see that as the benchmark for their own review. And that means that you know, relatively small agencies are up for similar fights as the Commission is up to, and that makes it very difficult to handle these cases. I think there are a number of causes for this development. Obviously, one thing is the more economic approach that is adopted also by the courts that was already discussed by the previous speakers. But I think an element that here is what is maybe slightly different from cartel cases and maybe even some merger cases is that the national competition authorities, all competition authorities, are fighting against well-resourced dominant companies that often have made significant profits from their businesses. That's why they're dominant, and therefore they have entrenched positions that they're willing to fight, and with fairly unlimited resources. And of course, from a government's perspective, we can set our own resources against it, and I'm not saying it's an unequal fight, but it is a fight that is extremely resource intensive, probably the most resource intensive fights that we are up to. And then there is a third element that I think comes into play, is that we handle these 102 cases as cases with a sort of quasi-criminal nature. We impose a fine. And that, of course, has logically implications for the rights of defense that can be used, and rightly so. I'm not disputing that, but that is just a fact of life. And second, it also has an influence on the evidentiary standard. In a quasi-criminal situation, whatever you want to call it, but a beyond reasonable doubt standard of proof is not unreasonable by itself, because you impose a fine. It does make sense to have, for wrongdoing, to have a high standard of proof, and therefore the system we found ourselves in make it very difficult to run these cases by national competition authorities, and that's a pity, because I think with Olivier, I see that in these concentrated markets, the enforcement by competition authority of the 102 rules or the national equivalents will become probably even more important in the future than it is now. And I wouldn't be surprised if we see a shift of resources by national competition authorities, maybe to a lesser extent on cartels. Of course, we will always have cartel enforcement, but if you look at how to divide the resources between cartel enforcement, abuse of dominance, and merger control, I wouldn't be surprised if there will be more abuse of dominance and merger control investigations and resources devoted to these activities, and slightly less to cartel enforcement. Whether that is right or wrong, I think it is a natural development that unless we get more resources from the government to do everything, which is very unlikely, we have to prioritize. And these types of cases are important to run for a competition authority to remain relevant and also to fulfill the mandate that we have towards the general public.
Thank you very much, Martijn. I'll move now to Marisa. Marisa, your views on 102 and the debate so far?
Thank you. Yes, I will present afterwards some of our Article 2 and National Law 2, Article 102 of the treaty cases. We have 5 this year. So in 2022, which I think is a respectable number of Article 102 cases, and they are very different the one from the other. So you will see we have a bit of everything, including exploitative abuses like excessive pricing in one of the cases. Of course, I concur with what has been said by other enforcers, as you can expect. I think that there has to be a balance that allows us to really administer Article 102. And there has to be also legal certainty for the companies, which is the other side of it, because their legal certainty is also our capacity to administrate the articles, so that we finally know what is precisely the standard of proof. You have raised an issue, Ioannis, afterwards about the evidence value in another sense that is more the general question of indirect evidence and other things that is common to other areas of competition law, not only to 102. Maybe later, if we have time, we discuss that, because I think it takes us outside of the scope, but I'm happy to take up that issue afterwards. When I read about the academics about the Intel judgment, for instance, and some people consider that this is a Copernican change compared to previous case law. I fail to see it. You will see that in one of our cases, we had rebates, retroactive rebates that we consider to be loyalty-inducing rebates. And there we are following post-Denmark. And the issue of as a competitor test was not put forward by us, and it was not put forward by the parties during the administrative review. Which counters a bit the impression that you always have to do that assessment in expectation of what the parties can bring forward. But it may be just us, and it may be a single case. I have to say that when we are making our decisions in Article 102 and Article 2, we are looking very closely sometimes also to the opinions of the Advocate General. Because, as has been put forward by several speakers before me, and in particular by Giorgio, I think that, of course, case law is, very case-specific. Already the cases that go to court are the cases that we have chosen to pursue. So, I mean, at least we have tried to pursue cases that we thought deserved action from the competition authority. So let's say that the scope of cases has already gone into the side of what could be a problem. But then the final issues that are discussed in the court are just a few of the issues that have been relevant. And normally, because in the court they have to agree on a text, and that also explains what has been criticized by another speaker. Sometimes the Advocate General opinion is more free to express in full a way to go. And there, for instance, it is very typical that we look into the opinions, for instance, in the case of a Postbank, of Intel, and the other case of the Post-Denmark 2, the opinion of Cocotte with the opinion of Val when he was the Advocate General. And I think that it would be good if we can discuss those things, because they really go into matters that are not completely discussed by the case law. So to sum up, for us, it is a very important line of enforcement, Article 102, and we try to be brave. And despite the review of the courts and the standard, the economic standard, and our very tight deadlines to come forward with decisions in this type of proceedings, we have done our best to tackle a considerable number of cases that we will discuss later. I agree with the speakers that there is no need, of course, to go into the consumer harm as a standard, but sometimes you find the consumer harm, and when you find it, you have to tackle it, because that happens from time to time. And then the efficient competitor test, as we will see, I have already mentioned that you don't always have to tackle it, and I think that a lot of people who are discussing this type of cases are reading a bit too much into a single case, because often that case doesn't deal with all the issues that former cases have been dealing with. And then because the focus is in one topic, there is an immediate impression that is in contradiction with everything that was said before. And it is only in a few cases that really the standard changes, meaning that under the new standard, the former case would have been wrong. And those are the only cases in which you can draw those conclusions, Would the former case have gone into the same direction as this one? So I think that these are just common sense principles when we are reviewing past cases and case law, and that is a bit what we are applying, because as has been explained by other enforcers, we don't have infinite resources, so we have to do what we can do in these cases in a way that is economically sound, but it is also possible within a reasonable deadline.
Thank you very much, Marisa. So coming back, first we'll start with Eleanor and her comments on what was discussed so far, in case she has, and then we'll pass the floor very quickly, though, for 1 minute for comments on this first round. There's some questions from the floor. One from the audience. One concerns the distinction between price and non-price cases. So one member of the audience says, well, you know, are we now subject to much stricter standards for pricing standards, I mean, for the Commission or the national judicial authorities for pricing abuses with regards to more lenient standards for non-pricing, leveraging type of abuses? Is this an inconsistency here? The second question is, and I will read it all, should fairness be taken into consideration in effects-based analysis, given the recent open investigations of the European Commission in disparagement conducts? And I think there's not only the Commission that has this type of cases concerning disparagement of products, and this is a little bit the type of examples I was referring before about the naked restrictions, the AstraZeneca, you know, the Irish sugar, you know, this type of, there's some litigation probably cases that Marisa will talk to us later. So we have there is fairness really taken into account. So how can it work in this effects-based analysis that some of you have been discussing? So let's start with Pablo first, and then then there's Heike, and then Giorgio. Pablo. Sorry, Eleanor first. Sorry, I'm really sorry. Eleanor first, then Pablo, then Heike, and then Giorgio. Eleanor.
Oh, okay. Thank you very much. I'll make very few comments now because I want to set a different stage in a little while when I talk about the U.S. law. So I'm very taken by your analysis of what it means to have an effects test. And I also, as I will say in a few minutes later, it's actually, there's a different formulation in the US that makes one start from a different point. And therefore, when I look at your cases on effects test, it seems like they're so incomplete. For example, I mean, of course, you read Intel and you don't know what it means to do an effects test. You read MEO and they say they're doing an effects test, but they're really looking at one player in the market as if that is the whole market. If you read Google Shopping, this actually implicates Bronner, and you're saving Bronner for later, and I'm going to bring that in when I come to US. But if you read Google Shopping, it's extremely difficult to understand effects when market share is only in one market, I think it's UK, as a result of preferring itself. It gets more than 50%, and even with more than 50%, there's lots of competition. So effects on what? When we do US analysis, we are number one looking at effects on consumers. It's not the end of the story, and there could be effects upstream as well as downstream, but it's very anchoring to look at, is there an effect on consumers? And even though I think it should not be a be-all and end-all in terms of output limitation and price rise, when there is output limitation and price rise, that is extremely anchoring in the analysis as to what it means to have a negative effect. I'm going to stop there. I want to bring in fairness too, but I want to bring it in later when I do my analysis starting from a US perspective.
Very useful, Eleanor. Thank you very much. Your comments also from a perspective of the US antitrust lawyer, as well as EU lawyer, so the comparative perspective. Let's move to Pablo.
Great. Thank you, Ioannis. I'll be brief, and I think I'll make a point about the issue raised about competition on the merits, abuses by object, etc. And perhaps to clarify and to mention that I don't think we're in any disagreement. So then the category of abuses by object very much exists, which means that if we show that a practice by its very nature goes against competition on the merits, that should be the end of the story. You mentioned already a few examples. I think one pending example that illustrates the point very well is Lithuanian railways, right? The only plausible explanation in that case why a company was destroying its own property is because it intended to drive a rival out of the market. Right? So then that category exists, and that means that to the extent that a practice can only be plausibly explained as a means to harm competition, the category of competition on the merits makes sense, right? The point I made, which was a slightly different one, is whether we need from an authority to show in every instance that the practice goes against competition on the merits. That's a separate question to which I think the answer is no, right? So then just to mention an example, just to leave it there, I think in a case like Google Shopping, the General Court went to great lengths to show that the practice in question was not an expression of competition on the merits. And I think the case could have been run perfectly well without addressing that aspect. In other words, in a case where we have evidence of anti-competitive effects, it is not necessary. It is one route, and there are some practices that in themselves are against competition on the merits, but it does not follow from that idea, which is fairly uncontroversial, that competition on the merits will be relevant across the board. So on that front, I think very much in agreement, and we might see, as you mentioned, some future cases where, again, we see this by-object conduct where the concept will be relevant. I will leave it there.
I think you refer to past cases, but as we will discuss in a moment, the national competition authorities, because of the difficulty of the effects approaches, they tend to favor in a way, I mean, more these type of cases in their case selection. So future cases might be a lapsus that was actually correct. So let's move now to Heike. Sorry.
Thank you, Ioannis. Well, first of all, I would want to go back to the question of this evidentiary standards of proof and so on, and designing the right test. I think we currently run a risk that we will, and this is also about how much of an effects-based approach shall we have. I agree with you, Olivier, that effects-based approach is something we should have, and that in a way it was always behind the case law somewhere, but it may have been become too formalistic over time. And it was good to go back to this basic idea of an effect. But what we have to take into account is that the overall benchmark for error cost minimization in Article 102 enforcement cannot be each single case, but must be the overall enforcement record. So if we have a very good effects-based test that will help us to minimize error costs in each single case, but proceedings will take 8 years until we are clear, this will not help us with enforcement of Article 102, and therefore we need something that can be done in a relatively brief period of time, and also provides legal certainty to companies ex ante. So I think maybe we should not move away completely. I don't think we are really on a very different plane there, Giorgio. I don't think we should move away completely from certain categories of conduct. I don't think, we should at least have an idea of what are the overall theories of harm, and then provide criteria that provide a good baseline. Otherwise, what we run the risk to see is that ever more Article 102 enforcement will be outsourced into regulations, or we will need something like a new competition tool, or maybe this was something that Leitenberger suggested in his keynote speech in Mannheim recently. The council may want to specify what Article 102 amounts to in a regulation, which is an interesting idea, but I think it's also a risky idea, because we will run the risk of more politicization of competition law. So we should really have a joint interest in making the normal Article 102 Article 102 enforcement manageable. And then regarding the fairness point, this is the second point I want to say something on. I think there are two relatively easy rules, and that have been applied, that are part of the case law. So one is the no economic sense test. If you have a conduct that is exclusionary and that has no pro-competitive justification, it can be outlawed. And if the reason why it is not pro-competitive is that it runs counter to the law, or AstraZeneca, it abuses the procedure, whatever, fine enough, so fair enough. It should be outlawed, and we don't need a more effects-based analysis. I don't think this is a general move into a new fairness goal. I think it's simply like a common sense and already very much ingrained in the case law. The other principle we can establish is that if we have a conduct that is exclusionary, but there's a very strong pro-competitive justification, this conduct should be legal. And you may have a possibility to rebut that presumption. And this is basically my understanding of Bronner. We have a conduct here that is normally legal, and then under some very constrained circumstances, it is illegal. Then the bar establishing illegality is high. But if the market circumstances change and we have a setting where such conduct, refusal to deal, is no longer normally clearly legal, then the bar can be much lower. And this is how I understand Google Shopping. These was a setting where the normal presumption that underlies Bronner was no longer applicable. So with these two principles and the third principle, I think the third principle can be if a conduct is exclusionary, but and has a pro-competitive justification, but the same efficiencies can easily be realized by another line of conduct that is not exclusionary, then this type of conduct should also be illegal. And then we have the rest where it becomes difficult. And this is where we have to talk about effects. And so this is what I wanted to say. Thanks.
Very interesting, Heike. Thank you very much. Giorgio, 1 minute so as to move to the national competition authorities. Yeah.
Sure, I'll just say something then about naked restraints. I don't think this category actually exists that is any different from a presumption. So if you take the Lithuanian Railway, if they'd interrupted the service for 1 day, that would not be an abuse of a dominant position. It is because they demolished the line and prevented the practice from actually taking place. Conwood is the case about destroying your rival's products. Well, if you destroy the rival's products in one shop, that doesn't foreclose market access. So I think you do need more than just the act. It's the act of such significance that leads to economic foreclosure. It's just like predatory pricing. If I drop my prices for 1 day, that's not predatory pricing, even though it's well below marginal cost. It has to be sustained over a long period of time. So I think to have life too easy is problematic. I'll leave it there for now. Thank you.
Excellent. So that brings me now to the national competition authorities, and in particular the way they implement their national provisions, equivalent provisions. So we can start with, I don't know, Martijn, you'd like to come first, or Marisa maybe first, and then Martijn. Yeah, Marisa?
As you like. I have a presentation. I'm going to project it.
Sure.
Please let me know if you see it already.
Yes, we do see it. Thank you very much.
That's fine. Maybe I just want to add one thing. When you were discussing before these disparaging acts, apart from the possibility or not to take them up under Article 102, we have another article, which is Article 3 of our law, that allows us to tackle those conducts irrespective of whether the company is dominant or not. I'm not going to speak about those cases, but that is an interesting way of solving the issue in many cases where the acts are just problematic. And I mean, I can explain that later if you want, but let's go to the presentation because there are enough issues here. So I'm going to the second one. So I was saying that we had these 5 cases. I'm going to discuss the first 3, not because the others are uninteresting, but they are very peculiar. So the number 4 is on the Royal Canine Society of Spain There, somebody was mentioning parallel exports and whether somebody was taking care of that. It was not exactly the angle that we took in this case, but it is a situation in which an association, which is the only one after liberalization that can give the export pedigree for dogs to be exported, only allowed its own pedigree dogs to obtain this export pedigree and not from the other associations. And also it restricted the judges that had been participating in the canine competitions from participating in exhibitions of rival associations. There is much more to this, but I'm going to leave it at that. It's just for you to have a taste. Of course, if you want more explanations about this case, I can give them. Another one is another NL case. So there is not only the NL case that was discussed in Italy. We have a different case, NL Green Power. It was a situation that already received a regulatory sanction from our other hand, the regulatory part of the CNMC. But in this case, NL Green had abused its position as being the official intermediary according to the law for all the companies that promote renewable energy generation in order to have access to the power transmission network. This company, NL Green, one of its parts, has to propose to the national system, to the administration, the order of prioritization in the processing of requests. And then what it did is that it prioritized its own request, not directly the own request of that legal entity, but of another legal entity of the same group. Okay, so it is a kind of self-preferencing in this market. But I'm going to dwell first on this sham litigation case that Ioannis was expecting. So this is Nuvaring is a hormonal vaginal contraceptive ring, and Merck Sharp and Dom had exclusive rights in Spain to manufacture and to wholesale this ring. As I put there, is since 2007, and the expiration of the patent was due in April 2018. Okay, and then there was a competitor, Insud Pharma, who manufactured under a different patent because it has different, it's not a copy or it's not a generic of Nuvaring's patent. It's a different way of having a ring with different material, which can be preserved without cold. So in some senses, you could say that it was even a superior product. Okay, so before the patent expired, MSD launched 2 sets of court proceedings. That was in September and December 2017 against Insud Pharma for an alleged infringement of Nuvaring's patents. In our inspections, we got direct evidence in internal documents, that is the internal discussions, of the exclusionary intention and also of the awareness that there was no infringement, because although Insud Pharma had offered its rings to MSD for them to check, to test them and to come to the conviction that it was a very different product, MSD had refused to get those products. So this would have come with a confidentiality clause. But of course, since the rings had started being sold, we got evidence that they had actually bought the rings and that they have tested them. So internally, they already had the conviction that it was not, in violation of the patents. But nevertheless, they went to the judge in Spain and they requested interim measures, which were obtained. So the producing plant, which was in Spain, and distribution was effectively blocked. It was blocked all over the European space because it was produced in Spain. And then 3 months later, the court withdrew the interim measures because, and this is said in the judgment, because MSD had provided misleading information, the data were misleading, the judicial experts had only had contacts with MSD and not with the other party, and anyway. So it was clear that there were no grounds for the injunctions. So we applied, let's say, the precedents, the ITT Promedia case from the Commission on sham litigation, and of course, these principles in AstraZeneca about misleading information to patent authorities. And then we established cumulatively that the action was not used to establish the rights, but to harass competitors, and the evidence of the plan to eliminate competition. So we worked out the illegal profit also, which is relevant in a way for the fine. This was the fine that was imposed. On top of it, we have an extra issue, which is it went black, which is the public procurement ban, which is a quite interesting feature of our legislation, because of course sometimes it can harm more than the fine. I want to draw attention to the fact that the complaint came to us in April 2019, that the formal opening of proceedings was in November 2019, and the decision came in October 2022, taking into account that two bodies have to take part here, the Directorate for Competition bringing the case and the Council making the decision. Another case that we have in common with Martijn, with the Netherlands and other colleagues, so maybe he will come back on this, is Lidiant. What is special about the Lidiant case in Spain, let's say, is that we have found both an exclusionary abuse and an excessive pricing abuse, not only the excessive pricing abuse. And the other thing that is maybe special is that let's say the basic principle or ingredient is produced in Spain, and despite all of that, we are importing the product from Germany because the price is much higher this way. So Lidiant holds the only medicine available in Spain to treat an ultra rare condition, that is this disease that is very complicated. I have there the name of the disease, but it's a condition that affects a neurological development apart from other things. And the chenodeoxycholic acid is the principle that is inside this medicine that had actually been used since the 70s in other medicines. The medicines were those, Kenobilan and Kenocol, by other parties, okay? And you see that the price at the time was this one. But then Lidiant, I don't go into full detail, but let's say started buying out the producers of these products, these medicines, up to a moment that was the only one having access to these CDCA drugs. So since September 2010, it produced a product that was called Sembilox, imported into Spain, and you have there the progression of price at that moment. So in June 2017, they formally withdraw the product and they exchange it into another product that is called CDCA Lidiant, which is basically the same. There is no substantial added value compared to Sembilox. So virtually there is no investment in research and development because and in clinical research, because they could use the tests that had been made with patients for the former varieties of products. But then it obtained the denomination, the EU denomination, as orphan drug. This is because this ultra-rare sickness or illness has, for instance, 50 patients in Spain, and is 200 to 250 in the whole of Europe. So it qualifies as orphan drug. So that provides them with 10 years of exclusivity counting from June 2017. And then it started importing it into Spain from Germany at 14,680 euros per pack. You see the figures before and the figures after this happens. You have them up and down. So even if the product is produced in Spain, we import it from Germany. So then they also introduced a delay in the negotiations with the Spanish health authorities to avoid imports and to sell directly in Spain at the price that would have been agreed with the Spanish authorities. And finally, during our intervention, there is a first moment of reduction of the import price that went down from 14,618 to 7,000 something. So these preparatory practices I have already mentioned, the acquisition of the competitors, but then there was also the foreclosure of magistral preparations, because there was slight scope for the hospitals in Spain to use the CDCA, if it could be obtained from the provider, and then do individual magistral preparations. And this was something that started, and then there was an action from Lydian to stop it. In that case, it was a legitimate action because the provider was not, it was a Chinese provider that didn't have all the specifications that were required. So that is not taken against Lydian. Then the other issue that I have mentioned, the removal of the other product, the sharp price increase, and the creation of a new brand and company, Lydian. But then we consider that there is established a dominant position, and thanks to all these preparatory practices, and then the abuse consists in an exclusionary part in maintaining the dominant position, which creates barriers to entry for any possible other company. You have to know that when you have an orphan medicine, the patent is such that you could theoretically have another provider if they can make a product that is substantially better than this one. But in order to do that, you of course have to have access to the relevant hospitals where the doctors are, to the data, and to the patients. So the key data are essential for research. But Lydian had exclusive agreements with those indispensable actors since 2014. And then it had also an exclusive supply agreement for the input with the single EU provider since 2016. So this didn't vary after the acquisition of the dominant position. And then this allowed for the exploitative abuse, the excessive pricing. There we applied the United Brands case law. So we saw the disproportion of risks and costs, applying a number of economic assessments. And we saw that the profit was 223% on average compared to the sector average. And we also saw the unfairness in itself, and we used as a benchmark, not other products because there were no other products, but the former CDC drug that had been removed in order to change the name and just ask for the special protection. So that was a fine, and on top of that, we imposed the duty not to enforce the exclusivity clause in the supply agreement in order to enable that this input would allow the hospitals to make magistral preparations, and the duty to sell the drug in Spain directly at the price that had been agreed and approved by the health ministry. And again, the opening of proceedings was in December 2020 and the decision in November 2022. And then I will try to be quick on this one, but it's an interesting case, and this comes with what I mentioned before, the question of the post-Denmark II, the question of Intel, the tension, possible tension between Advocate General Val and Advocate General Cocotte in those cases. So we opened ex officio proceedings against Correos. Correos is the postal company that was subject to liberalization in Spain, but that still retains an obligation of universal service until the end of 2025 for some part of for the traditional mails. So we analyzed the Correos discount model, and we took as a sample 59 contracts with the most important, with utilities and those who are the biggest companies selling out letters, let's say. And that these 59 contracts accounted for 80% of all the clients that were relevant of Correos. So it's the biggest clients. And then we could establish the conditional and retroactive nature of the discounts. There is a scale of 17 discount thresholds. We will come to that a bit later. That there was a substantial increase of the discounts for deliveries, in particular over 500,000 letters. This is important because out of the 59 contracts that I was mentioning, only 5 were below the 500,000 letters. So really, that is a moment where the scale of the company is important and is a situation in which you will see that the step is very, very big. Then there were significant reductions of Correos revenues after applying the discount. There was an aggregation of volumes, local and urban destinations, which just increased the suction effect that we will see in a moment. There was lack of transparency and of standardization across clients. So there was supposed to be a model that was applied, but then this model was never applied in practice. I mean, you had the situations in which the discounts were well above or well below the maximum and minimum levels that were supposed to exist. And in the contracts, it was not explained how the Correos arrived to these accounts, to these numbers, to these figures. And then the duration of the contract, this we did also to compare with the Postbank 2, was about 1 year up to 3 years, a number of cases with automatic extensions. And well, the question about the bargaining power. So the exclusionary practices we found in the mass mail services were achieved by finding first the nature. So the first step in Postbank 2 is to establish the loyalty building effect or suction effect. So one of the things that we looked into was the estimated, instead of going into saying what another competitor, for instance, would have had to offer, what we estimated was the cost increase for a client that would lose the benefit of the discount. So a client not reaching the threshold of 20% would lose more than 20% of a discount. These discounts were given annually. So first, every year, there was an estimation of what was going to be sent. But then every year, you had a review of that, and all, of course, the discounts were applied to everything that had been sold in the year. So you see that this penalty, let's say, of 20% was much higher than in these other cases, previous cases of the Commission.
Marisa, I'm sorry to interrupt you, but we'll have to conclude because...
okay, and then just to say this, yes, the scope of the dominant position and competition context, you see that the market share was always above 85%, sometimes 95%, so the super dominance. We looked into the customer coverage as in the precedent, and then we established the high barriers. And just to say, it was very interesting to know that in this period, the only rival that existed with real importance, because the others were each of them less than 2% of the market and altogether 5% of the market, was Unipost. And there was exit from Unipost, who had these percentages, these shares. And you see that it started in 2015 with 14.10. There is a decrease in that market share. The decision doesn't say that it was cost the exit of Unipost that was not expressly mentioned, but it is a fact that this happened. Again, the practices were from 2015 to 2019. And again, it's another decision in which the opening of proceedings was in November 2019 and the final decision in February 2022. That's very quickly what I wanted to share. Sorry.
Thank you very much, Marisa. Very, very interesting. Let's move to Martijn. Martijn, the floor is yours.
Thank you. I will keep it brief so that we also have enough time to discuss the US developments. And also because our track record is far less impressive than the Spanish track record. Maybe by way of background, Dutch competition law is an exact equivalent of European competition law. We have no economic dependency or any other prohibition in our Competition Act. So we apply the 102 equivalent of in Dutch national law, similarly as the European Commission. And the intent of the legislator and the courts is also to follow closely the development of European competition law. If you look at our track record, we had a case that we issued imposed a fine in 2017 on the Dutch railways for a predatory pricing case that we lost in 2021 in the highest court. The decision was quashed in full. I cannot say much about it as I was involved while I was still on the other side, so it would be kind of inappropriate for me to comment on that case. But what I can say is that it was typically a case where, from an agency's perspective, where the loss was felt internally. And it was hard to get back on the horse again, if you can put it that way. After that, we came with the Lenient case that Marisa already referred to. I think we were the first authority to impose fines on Lenient for excessive pricing. And then the next case was our famous, I think, Apple case, which was also a case based on exploitative abuse, where we looked at three elements of abuse. One was the exclusivity obligation for the App Store. Second, the anti-steering rule, and a third element that remains under seal, which is still confidential in the public domain, so I cannot talk about it either. All these cases, also the Lenient case, is under appeal. So this kind of demonstrates the point I made earlier, how resource intensive these cases are, not only during the investigation phase, but also before the courts. The final case I mentioned is a commitment case where we entered into, if we may so, a settlement with KPN, the telecoms operator, for access conditions to the glass fiber network, which was interesting because it was a case that could also be, in theory, be dealt with under telecoms regulation. And we initiated an investigation both under telecoms regulation and under general competition law. We settled the part under competition law, so that is, could in theory be appealed, but as far as I'm aware, there is no appeal pending. I think what these cases show is what I said already earlier, how difficult, resource intensive these types of cases are. And I think this is also known to the legislator and the policymakers. And the policymakers in the Netherlands have expressed their concern about the administrability of abuse of dominance cases. And now our track record and also the entire system is under review. And I think we don't know what the result will be, but generally not specific for the Netherlands. But I think there are two trends that you can already discern from the current practice in Europe. And first is something that Heike already alluded to, is the rise in the increasing pressure on national new competition tools to see of ex-ante enforcement and ex-ante rules can maybe solve the perceived, let's put it that way, under enforcement of abuse of dominance. And second, the focus on exploitative abuse. And I will briefly discuss both points. The rise of kind of interest in the new competition tools come, of course, from a frustration by policymakers, maybe also by competition authorities, how difficult these cases are. And the hope is that a new competition tool, or in what shape or form it will be, will solve some of these problems. I subscribe to the idea that in an ideal world, ex post enforcement of 102 type rules would be sufficient. But I think the reality is that the general public expects more expedited, more targeted, more forceful enforcement. And I wonder whether our current system, 102 system, is able to deliver that. And therefore, I see my prediction will be that around Europe, more new competition tools will be put up. And that means that competition authorities or the ministries themselves, you can have various systems. You can have a system where the obligations under a new competition tool are being imposed by the national competition authority, or you could have a system where the rules, the conditions are being imposed by ministerial decree or some sort of delegated legislative act. Two systems have pros and cons. But in any event, the idea is behind it is to bring this out of these quasi-criminal system and make it into a system where it's easier to maybe to change the burden of proof, to have different balancing of different tests applied of when and when not to intervene, and particularly when you put the powers of intervention into the hand of the minister, to have more democratic legitimacy of an economic intervention into the functioning of the market. It is a political decision that needs to be made, and I think the development, no doubt, will create also new challenges, not only for competition authorities, but I think also for Europe. A fragmentation of the internal market where different countries have different national competition tools and may find different remedies appropriate against the same dominant company that is active in different national markets. And I wonder whether, what we think of that system. You can have some serious doubts towards such system, but if there is a perceived lack of enforcement, I wonder whether we have a legitimate right to oppose this development. Therefore, I think the challenge for national competition authorities and for the ECN, the European Competition Network, as a system, is not necessarily to embrace this development, but to take stock of this development and see if we can somehow find a way where the new competition tools that are being created around Europe, at least there is some sort of coordination, some sort of exchange of best practices, and see this as a kind of a new tool in the toolbox, not necessarily of the competition authorities, but of competition policy in general, and see if we can find a common ground across Europe. So this is first development I predict, that is the rise of new competition tools. Second is something that competition authorities have in their own hands, is whether they will use the 102 or national equivalent prohibition to attack exploitative abuse. And I think that is something which is quite interesting, because I'm not suggesting that exploitative abuse cases are easier, but at least it is more uncharted territory. And there are pros and cons to uncharted territory. The con is you don't know exactly what the rules are. The pros are that allows, for more development and more room for experimentation, for venturing out into areas that were previously unknown. And I think traditionally, exploitative abuse was very much focused on prices. I think we have a relatively stable standard of review when it comes to excessive pricing. But when it comes to unfair trading conditions, the second leg of 102A, the number of cases in the case law is very fragmented. It's difficult to find a consistent a trace of the law. And there, I think the national competition authorities, together with the courts and the European Court of Justice, when it's issuing preliminary rulings, can create some more consistency in the case law and can develop this case law more. I sometimes see it's so 102A cases outside excessive pricing are a little bit kind of the ignored child of competition law. And under, I think it is rightly so, and I think that's all we owe that to the general public, that exploitation of market power is something that we should take into account. I agree with many that the first best solution in competition law is basically the restoration of the competitive process. And if we can do that by attacking exclusionary behavior, we can restore the competitive process. At least that's what we aim with that. But in many cases, the barriers to entry are so high, or markets have tipped, that the idea that exclusionary an investigation into exclusionary conduct can actually open a market again may be not realistic. And then the only tool that we have is a case based on exploitative conduct. So therefore, we need to develop these types of cases. We need to do this coherently. It's good to do this in the context of the application of European competition law. So at least we all can learn from each other and can learn from each other's experiences. And I do see a greater emphasis by national competition authorities on these exploitative cases. Our own cases, the Lenient case and the Apple case, are good examples of that. In the Lenient case, of course, it was a relatively traditional exploitative abuse case when it comes to excessive pricing, while our Apple case had a more novel theory of harm on exploitation, was focusing on unfair trading conditions. And therefore, the development of this case through the courts is going to be interesting and could be a spearhead in the development of the case law. Of course, the question is, what is the role of the national competition authorities next to the DMA, where some of these issues are targeted. I think if we speak for ourselves as the Netherlands Competition Authority, our role and how we see 102 cases is particularly in the area that are not covered by the DMA. So either abusive conduct by companies that are not considered gatekeepers under the DMA, or behavior that is not covered by the DMA. So I think in the system, also in the efficient allocation of resources, it would make it would make sense for competition authorities to really focus on those cases where there is no overlap between the DMA and with the DMA, because we all need to deploy our scarce resources efficiently. That goes for the European Commission and for the national competition authorities. So, in short, there is I think the development, the more economic approach and everything that comes to it will have an impact, a policy impact, and I think in two important ways. First, the emergence and the acceleration of new competition tools around Europe, and second, the development of exploitative abuse cases.
Thank you very much, Martijn. I think I was very optimistic having 2.5 hours for this debate. I think we could go for hours. It's extremely interesting. And for the interest of time, I will actually skip my presentation very briefly to say that in Greece, the last couple of years, since 2021, we had 5 abuse of dominance cases. 3 of them actually led to an infringement decision. 2 of them haven't been published yet. They will be very soon. So I will only comment on one of them, which concerns a company in non-alcoholic beverages, a very well-known one. This case concerned basically a mixture of verbal exclusivity agreements as well as non-meritorious exclusion of specific competitors with the aim to promote single branding, in particular, basically issuing threats or engaging in punitive behavior in cases some outlets, the outlets decided to cooperate with competing suppliers, as well as practices concerning, for instance, the removal of competitors' products or refrigerators from the points of sale to cover up the competitors' labels and brands from their refrigerators. And the mixture of these practices was actually found to be an infringement of Article 102. Interestingly, we dealt also with the Intel case, and we implemented the Intel case here with regards to rebates type of practices. We had actually to deal with we decided to deal with also the insufficient competitor test that was put forward. Even we did not have the obligation to look at that in the context of the oral exclusivity agreements. We assessed and dismissed the specific type of test as unconvincing. We decided to impose a fine of 10.4 million euros on this company, as well as to impose a behavioral remedy for a period of 2 years from the publication of the decision to restore competition, basically by opening up the refrigerators of this company in the various outlets, 20% of these refrigerators to competitors, because one of the things we discussed in the case, and we had actually a potential effects analysis there, was that since basically the specific type of practices affected a very long period of time, so we saw that they contributed to the fixed hierarchy developed in this specific relevant market, with the fact that this specific company had a very important dominant position for a significant period of time, and despite the product variety and innovation tried by the various competitors, they weren't able to have access to, because of these practices, to a significant share of the various outlets. And more generally, we consider that the type of practices that were adopted were not basically made economic sense, but for the exclusion of these various competitors. So, but of course, I think the debate raises interesting issues, and I will pass the floor to Eleanor. We discuss about the role of national competition authorities. Martijn and Marisa mentioned a number of somehow pressure valves that we have, like the no competition tool type of discussion to get out the pressure out of the concentration that we see, but the difficulty for competition authorities to act by implementing Article 102. One might think also the possibilities offered by Article 3, Paragraph 2 of Regulation 1/2003 to have a stricter national laws for this type of unilateral behavior. Maybe, moving to lower standards. Of course, Heike mentioned the policy element of having the council coming in and adopting regulation with regards to the status to implement Article 102. To a certain extent, the move towards a more economic approach was a decision by the Commission. The council has a possibility theoretically to come in and somehow, in case they think that we need to have stricter standards for regulation to provide this type of direction. I mean, that's an interesting suggestion. But let's move to a federal kind of system where, and also a system in change right now. I mean, in the last few years. Eleanor, the floor is yours to discuss about the U.S. perspective and, what does it mean, all this debate? Are we moving towards more convergence, more divergence with TS law? What is exactly the trend?
Okay, thank you. So I'm going to put some slides on in a minute. And one thing I'd like to do is keep in mind various threads that you have all contributed to this debate, because one big theme in it is things are very complicated and overcomplicated, probably, to get the enforcement that we want. And there has been an outcry in various places in the world, including my own country, of under-enforcement, lack of legitimacy, not responding to what people think ought to be enforcement against power. That certainly doesn't mean everything, but it's something that should be taken into account and listened to. So I'm going to put some slides on the screen, I think. I'm trying to.
Otherwise, we can try to do that ourselves. I mean, if it's possible.
Oh, so why didn't this go on? I don't understand.
You need to put share screen and then choose the. Oh, wait, there it is.
There it is. Okay.
So let's see. Yes, perfect. It works.
All right, great. So I will talk about convergence and divergence. And the question, one question you have raised is EU with effects and more economic approach getting closer to the US? However, that's one question, but the US law starts from a different place, and each body of law has a so-called mind of its own. And the EU effects analysis, when it exists, is actually sometimes a small piece of what US calls effects analysis. And I really don't see the EU more economic approach as bringing EU into great convergence with US. In fact, one thing I observe is maybe it's now time for US to come into greater convergence with EU on some broader ideas of harm to market process, for example. So I have here a title of convergence, which I just spoke about. And one observation I am going to make is that there is at the moment convergence on rhetoric, but not necessarily law, with our enforcers in the Biden administration speaking relatively the same language as Margrethe Vestager, talking about fairness, for example, exploitation, discrimination, and access. So the vocabulary of what you hear today by the top enforcers seems there's a greater alignment. But, and under divergence, the law is very, very far apart. And the law in the United States is, of course, if a US Supreme Court has ruled on the question, it's what the Supreme Court says. And for the Supreme Court, it has told us, excuse me, I didn't mean to go back. The Supreme Court interprets our counterpart to 102, which is Sherman Act Section 2, to be very, very non-interventionist. There's no duty of fairness, there's no duty not to exploit. I will go into greater detail. Our Section 2, US Section 2 of the Sherman Act, it says, it is illegal to monopolize. Oh, I meant to put myself on a timer, just a second, okay. However, that statute has not been robustly enforced ever. And particularly, perhaps it was in the 1960s, half of the 1970s, a little bit in the 1970s. We then had a Reagan revolution in the 1980s, when the common point of view was the following on unilateral action, that if a firm took action unilaterally, even if it was dominant, it was almost surely to help consumers, to do something innovative, to get the product to market better. And it was virtually never to harm consumers or to harm the market. This became a philosophical and ideological position, leading to the idea that monopolization, and of course the broader European abuse of dominance, should almost never be enforced, because when it is enforced, this was the story, it was almost always helping inefficient small competitors and ruining the competition system. So that section has been under-enforced for years. And while there have been some movements to make it more robust, the big movement came recently and on the run-up to the Biden administration. I should really say, in a way, it was on the run-up to even the election of Trump, when you could see a groundswell coming out and saying, we have huge concentration. It's working mostly for the elites. It's not even working for the middle class and the poorer people. And the antitrust authorities are sitting back and doing nothing. So Biden administration has said from the outset that it wants to reverse the ineffectiveness of Section 2. However, of course, it can't overrule, except unless legislation is passed, it can't overrule the Supreme Court case law. We have two federal enforcers. One is Justice Department antitrust, and one is the Federal Trade Commission. The Federal Trade Commission has been the more vociferous in trying to get a more robust Section 2. And also, it has an additional tool, which is Section 5 of the Federal Trade Commission Act, which says no unfair methods of competition. It wants to use that to fill the gaps. Meanwhile, there are a number of cases pending against big tech, for example, but will they succeed? If they do succeed for the government on the first round, they will go up to the Supreme Court, and the Supreme Court is much more than not likely to say these companies are innovative. They're doing what's good for competition and innovation. That's why US is so strong in innovation, because it doesn't have rules and that handicap firms stay out. The stage was set in interpretation of the Sherman Act in a case called Trinco, which I know all of you know. And it is an interpretation of our Section 2 of the Sherman Act. It says, and this was a case, incidentally, in the telecommunications area, where there was a dominant firm, which was the regulated monopolist, and then regulation was eliminated. And when regulation was eliminated, it actually put noise into its system so that the new competitors could not deliver a sound product and so that it would keep its customers from migrating to the new competitors. That was the background of the case. There was no violation found. The court recited a principle of freedom to deal. There is no duty to deal, and that principle is broad, way broader than Google Shopping interprets it. It's more the Bronner line. It's not the Google Shopping line. It's very broad. There is no duty to share advantages on the theory. If you've created an infrastructure, you ought to be able to get the advantages that you have created. There's virtually no essential facility doctrine. There's no levering violation unless the plaintiff can prove monopolization of a second market. There is probably no self-preferencing doctrine because there's no leveraging doctrine. There's certainly no special responsibility. There is a statement that monopoly profits are good. There is no exploitation violation. So Trinco is the law. Here are 3 applications that are very recent. Our Federal Trade Commission brought a case against Facebook. It actually brought it under the Trump administration. One charge in it that is still existing is that it acquired WhatsApp and Instagram, and those 2 acquisitions are allegedly illegal and should be disbanded. But there was another allegation that was thrown out, and it's not in the case anymore. And here's one example that comes up within that allegation, because it's about misuse of your own platform to exclude competition for reasons not on the merits. And the big example is Vine, small competitor using the Facebook platform, has a great new idea, and it wants to get to its users and have the users be able to send the new innovation on short videos to their friends. And as soon as Facebook learned of this, it cut off Vine's data flow. It went right up to the top, and Zuckerberg said, yes, cut them off. That was thrown out as a charge because there is the freedom of Facebook to do what it will on its platform. Epic against Apple. You know, there are a lot of cases against Apple. Apple has a walled garden. It prohibits, in this case, it's gaming developers who want to put their own apps on the Apple iOS and avoid the Apple 30% surcharge. The judge threw out the case and said, I cannot find that Apple is a monopoly. This, of course, is the first screen. You have to find out first the company is a monopoly. Second, that its conduct is anti-competitive. So is Apple just immune from the law that prohibits anti-competitive unilateral conduct? Third case, DC against Amazon, in the last several months, maybe 5. Amazon refuses to allow business users of its platform to sell at a lower price elsewhere, most favored nations clause. The judge here, as opposed to EU, obviously, threw it out and said DC didn't prove that the price was not monopolistic. So I want to come back to these 3 ideas, or they generalize into ideas. There could be a simple rule. There could be even consensus in the world stemming from those 3 cases that I think there would actually be a huge amount of consensus. This is wrong, this shouldn't happen. And to get to that point, we do case by case by case. It's very, very expensive. And in the end, those conducts might be allowed. So I mentioned the FTC is trying hard to reverse the limits of Section 2. It has recently put out a policy statement that interprets unfair methods of competition. It withdrew a previous policy statement that said, in effect, consumer welfare was the only test. And in this policy statement, it says Section 5 reaches various types of unfair conduct that tend to negatively affect competitive conditions. I have a half a minute. Okay. I think both those sets of words, what is unfair and what negatively affects competitive conditions, I think these are both phrases that have to be defined. You need clarity, but I think they can be defined. And I think there could be a way forward in the world to put these concepts on the map when traditional antitrust, if your antitrust is narrow, it might not reach it. This is Lena Khan on the right, obviously, the Steyer on the left. The Steyer speaking to Khan says now we are aligned, but it doesn't mean the law is aligned. The law is still an ocean apart. We have legislation pending. It has to be reintroduced in next Congress that would align our law more closely, actually, with EU. but the legislation does not have a really good chance of passage. So the last word I would like to say is drawing from all of you and your really interesting conversation. And I think I want to mention two people. I want to mention Martijn, because I agree with you that there are various unfair trading practices that might or might not get caught by the law on unilateral practices. And I wonder if there are principles that we can push forward and say, at least as an international consensus, yes, this should not happen without the use of extremely long trials with endless evidence. And I also want to draw really from all of you, but Heike, in your formulation of when is an action that a dominant firm does, when ought it to be prohibited, and your proportionality analysis I thought was really good. So I would leave it there and hope that we can, as a world, move forward with some consensus and joint seeking of some more simple rules that can be teased out, that could be at least in the spotlight of being illegal without billions of dollars spent. Thanks.
Thank you very much, Eleanor. That was extremely insightful. And of course, in addition to the federal initiatives in terms of legislative reform, there are also some states like New York, etc., that also try to converge more with Europe. So with abuse of dominance type of standard, interesting discussion. So showing that some experimentalism in the federal context might be the way to go, in particular, as also the political preferences might be different from jurisdiction to jurisdiction with regards to intervention, as well as the concentration problems might be also different. I would like to come up with 1 or 2 minutes, no more, for each of the speakers. And we left out the Oscar Brunner type of issue. So I don't know if Olivier would like to come in on this one, as opposed to the Trinco type of case law. So maybe let's start with Olivier, and then we will, go to the other speakers. Olivier, the floor is yours.
Well, thank you. I had spilled the beans, if you remember, in my first intervention by referring to Brunner. So maybe I rather would like to focus on the very interesting presentations of Eleanor. I think it is undeniable that the closeness of thinking between the DOJ and the FTC and us in Europe is probably is closer than ever, certainly. And the statement on Section 5 that Eleanor referred to is certainly the best example of this. But also, I think one can say that FTC and DOJ, but also state advocate generals, have launched a pretty much unprecedented number of lawsuits, both in antitrust and mergers, in particular in the digital field over the last 2 years. And some of these investigations resonate with some key aspects of our own investigations, not only the ones of the Commission, but also the ones of some of our colleagues in the member states. And we do regard this as a positive trend. But of course, I mean, given what is the American system, all this will really hit the ground or not when it will be tested in the U.S. judicial system, and we're not yet there. And I think this is the lesson of what Eleanor said. And if I don't misinterpret what she said, I think she's dubious that this will be entirely successful in front of U.S. judges. We shall see. But I think that how imperfect it is, what I see for the last 20 years is a convergence between US and EU concept. That is certainly very true in merger, and that is increasingly true in abuses of dominant position, despite the differences of culture, despite the differences in legal tests. You see a gradual convergence. We become more American, and maybe they become a little bit more Europeans indeed.
Thank you very much, Olivier. Let's actually move to the enforcers. Marisa, floor is yours. Do you want to make any comments on the convergence issue, or more generally what has been discussed so far? Yeah.
Yes, I think it's a very interesting point, the one that has been raised by Eleanor Fox and what Olivier was mentioning. I think that in a way, I mean, obviously for the cases that are just national cases, maybe this doesn't apply. It will apply on a second, as a domino effect maybe. But the fact that companies that are, that have distribution systems or that have, any type of practice that is worldwide or at least international, are confronted both to the European system and to the European principles and to the US principles, may make that in some circumstances would anyway apply the European system, because it restricts their possibilities of action in some situations, like in the abuse of dominance cases, but also in the DMA application. And that indirectly the US will benefit, if I can say it like that, from the action of the European Union, because maybe it is not so wise, at least in digital markets, to try to apply different rules in different jurisdictions. It may even not be that possible. So on top of convergence, there may be an effect of expansion of one of the systems, that it is just because it is probably the tightest in that respect. That's what I wanted to say.
Thank you, Martijn.
Thank you, Ioannis. I will, in the interest of time, I will abstain from comments, because otherwise I'm just going to repeat either myself or what others have said.
Okay, excellent. And let's move to Heike.
I do the same.
Okay, perfect. Giorgio, don't feel obliged.
I mean, maybe just one point. It might be worth prospectively thinking a little bit about why it is that one of the agencies today manages 5 cases and another agency struggles. So are there lessons to be learned about how to manage these cases more productively by some more intensive conversation between agencies and external studies?
Well, thank you very much, all the speakers. And Pablo has left a few minutes ago. So thank you very much for.
Can I say?
Oh, sorry, Eleanor. I'm really sorry.
Yeah.
Yes, go ahead.
Okay, just one word. I think it would be very useful and helpful if there can be some assembly to put flesh on the concept of harm to competitive process, because I think that is where we're moving, where US should be moving, where the Federal Trade Commission wants to move. The statement, which I told you about and put on the screen, is highly criticized in the US as it's rudderless. There's no way to know what's unfair, what's harm to competitive process. The EU use of harm to competitive process is likewise criticized by many, many people in the US as rudderless. I think that there can be a definition that scholars and enforcers around the world would agree to that could help clarification. Thanks.
Thank you very much, Eleanor, and thank you to all the speakers for their excellent contributions. It was extremely interesting, at least for me. It shows this debate that, the debate over the soul of Article 102 is not over. There's no end of history moment in Article 102, and I think the debate in the US, the vitality of the debate in the US after many years of stagnation, I would say, shows that change is possible. And of course, it's an extremely important issue that the European Commission, national competition authorities, but also authorities around the world will have to discuss in the future in view of the recent trend towards concentration. And the political also dimension of this issue. Thank you very much to all the speakers, and a wonderful afternoon to everyone that stayed up to 7:15 Greek time to listen to us. Thank you.
Thank you. Bye-bye.
Thank you.